Christopher Braswell,
Yes, sir.
born in 1999.
Yes, sir.
Last four digits, social security number 5737.
Yes, sir.
We're here in 25 CR 00088 for notice for new trial, Clinton Circuit Court. You agree to have this case heard here in Cumberland County?
Yes.
Okay, go ahead, Mr.
General, we filed this motion after there was a jury trial March 4th, 2026, where a guilty verdict was returned. One of the jurors, a number 173, we found out after the fact, had a great niece that she has helped raise who was a victim of this exact specific crime. And that defendant was tried and convicted right at 2 years prior to this trial. During voir dire, the court posed a question that we've laid out in our motion, asking if anyone has had personal involvement, a family member, close associate that would involve the allegation of sexual abuse that would prohibit you from sitting on a case like this. And that juror never responded. Then during voir dire by the defense counsel, we asked the question, is there anyone here who would prefer to discuss privately with the judge your ability to serve as a juror based on all of the questions that have been asked today? And once again, juror number 173 did not respond. Now, we found out after the fact, so we did not know at the time of the trial that this juror had personal involvement with the victim of a sex abuse crime. In her juror qualification form, she specifically on number 4 at the very bottom, it says, have you or a family member been a defendant, witness, or complainant in a criminal case? And she marked yes, but then under if yes, what year, county, and state, she simply stated husband was police officer for 27 years. Once again, not making reference to the child that she's helped to raise that was the victim of such a crime. We've stated in our motion case law that says if the juror is silent, that doesn't give us the opportunity to strike that person either for cause or preemptory strike. Therefore, we're stating to the court that because we did not have knowledge of that and the juror did not raise her hand or submit to the court that she did have that connection, my client's trial was unfair and we did not have.
What kind of connection was there again? What was the connection?
Her great niece, I believe age 4, that she is helping raise. She takes this child to ball games. She takes this child all around town, was the victim of a sex abuse crime.
Yes, Your Honor. As the court's aware, I didn't try this case, but there was extensive voir dire in it, about 2 hours. And this juror was asked this question by the court. She was also examined individually by Mr. Poindexter because her husband was captain in the state police. She was asked about Snapchat and all those other things. But the main key in this case is just for an example, as defense counsel a lot of times does, either the court or the defense counsel, they'll ask, is somebody related to a police officer? And that person's got an obligation to say they're a police officer in the family or something like this. This question is broad and it's subject to a lot of interpretations. It basically says, it's got qualifications on it. Do you have a friend or close association who's had an allegation of sex abuse that would prohibit you from sitting in a case like this? And then the court went on and further qualified and said that would bother you to sit in a case like this. Now, I know this juror, and Mr. Poindexter's right. She's got a great niece that has a sexual abuse allegation. She's also got another member of the family that was falsely accused of sexual abuse. And she could have, and based on my discussions with her, did interpret this question as, could you sit on this and render a fair verdict based on the evidence, or would you be biased? Now, Mr. Poindexter had every opportunity to follow up and say, does anybody have a family member that's been sexually abused? And if she'd said no in that case, then I think he'd have a proper motion. But this question is just too broad to rely on it the way he's relying upon it.
Your Honor, I would simply submit that the motion we filed is accurate and that we're entitled to a new trial.
I'm not disputing the accuracy of what's it contained.
Right.
I'm just saying it's overly broad.
How did you find this information out?
I received a call from the mother of my client that her sister knew that juror and knew the connection.
Mother, your client knew the sister of the juror.
Well, evidently, after I did some investigation on this, this juror's half-sister is married to some of Mr. Braswell's family, and her husband and his brother-in-law fish a lot. So I wonder if they were intentionally left on. I cannot foresee that Mr. Braswell's family member did not know who this juror was based on this family connection. So I'm wondering why she was left on the case.
Or that was a decision by me, not knowing that there was any connection.
Well, I'm just saying his family did.
Right. But
How much time did he get?
7 years.
That's it.
Well, it could very well be that the question was not as artfully worded as it should have been. Might should have been a bifurcate, ask if anybody had anybody in their family who had been wrongfully accused, maybe anybody that had been accused, maybe anybody that had been a victim. Maybe in the future we'll ask it, but the way the question was posed gave an opportunity for each person. And you really don't know whether that fact influenced this juror or not. I mean, the question that was proposed, if you have any exposure like that, would it prohibit you from sitting on this jury and rendering a fair and impartial verdict? And there's another general question at the end that's always asked: is there any reason that we've brought up that hadn't been stated? You made this motion appropriately, and I'm going to deny the motion for a new trial at this time, but you have made a record here, and you can appeal it.
Yes, sir.
Okay?
Yes, sir.
Thank you very much. When's he up for sentence?
May. You'll have to do the sexual.
Okay.
Yes.
James Shelton, Clinton, sir. Commonwealth versus James Shelton, 25 CR 0097. Are you James Shelton?
Yes, sir.
Were you born in 1963?
Yes, sir.
Last four digits, social security number 1997. It says that you're represented by the Office of Public Advocacy.
Mr. Rutherford called me this morning discussing this case. He said he'd been held up in instruction. He'll probably be about 15 minutes late, so.
Okay, well, we'll call you back up in just a minute when your argument's here, okay? Olivia Kendrick. Did he understand it? Commonwealth versus Olivia Kendrick, Cumberland Circuit Court, case number 26 CR 0003. Are you Olivia Kendrick?
Yes, sir.
Good morning. You were born in 1997.
Yes, sir.
Last four digits, social security number 8382. It's a motion to enter a plea, is that correct?
Yes, pre-trial version, Your Honor.
A motion has been tendered that says you wish to enter a plea today, is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person that we just identified in 26 CR 003? Was your judgment impaired today in any way? You need to speak up. It's a voice activated microphone unless you speak up a little bit. It doesn't turn the camera on. Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney and you're satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. A right to speedy trial, but jury, the right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand? If by entering a plea of guilty, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea, go to trial. I'm going to ask you a few qualifying questions. Have you previously been diverted in the last 5 years? Have you had any felony convictions in the last 10 years?
No.
Are you currently on probation? You understand if you successfully complete the diversion agreement, charges will be dismissed. You understand that?
Yes.
If you do not successfully complete the diversion, you will be brought back before the court. The court will schedule a sentencing hearing. You understand that?
Yes.
Mr. Hunley, are you going to present the Commonwealth's?
Yes, sir. Your Honor, upon a plea of guilty of possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years pretrial diverted for 5 years. The diversion is to be supervised. As part of that supervision, the defendant shall enter and complete the Cumberland County Specialty Program. She shall be released upon orientation for that program. The defendant shall obtain gainful employment or do a minimum of 30 hours per month community service per week until gainful employment is obtained. Any evidence found in this case shall be destroyed according to the laws of the Commonwealth.
Is that what you agreed to?
Yes.
Okay. Now, if you successfully complete the diversion program, as I said previously, the case will be dismissed pre-trial diverted and you can have your record expunged. However, if you don't successfully complete it and you're brought back in front of them, you'll be sentenced and you'll be convicted of felony and that can be used against you. You understand that?
Yes, sir.
Okay. Are you pleading guilty because you committed the acts charged in the amended indictment?
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Under your constitutional rights, so explains it's still your desire to enter a plea and allow the court to fix your case.
Yes.
Is that your signature on the motion and offer?
Yes.
Okay, what's the court cost?
$250.
$250. Do you need some time to pay that?
Yeah.
Okay. So I'm gonna give you a little bit more than that. You make your first payment 30 days from today and $30 every month until the 250 is paid, okay?
Okay.
I will accept the agreement, sign the pre-trial diversion order, and you will need to meet briefly with the probation and parole officer. Is it the plan for her to get out today, or has she got some days to pull?
I think she needed to be assessed today by Coach Murphy, that's why we had her brought over.
Okay.
I hate for her to have to wait until the next meeting of the Cumberland County Drug Court, especially court to get out.
Well, that'd be Thursday.
Oh, that'd be okay.
Yeah, they're meeting Thursday.
That'd be great.
So if we get her assessed before we do, so we can be voted on.
No, for these, gonna see her back.
Okay.
That's why we had.
And then they schedule orientation. If they let her in, we'll see how long it is to orientation. Y'all, if it's a long time, we can talk. Okay. Hey, thanks a lot. Commonwealth versus Ethan Combs. Commonwealth versus Ethan Combs, 26 CR 009. Are you Ethan Combs?
Yes, sir.
Good morning. What are the last 4 digits of your social security?
7698.
You have to speak up.
7698.
You were born in 2006.
Yes, sir.
Okay. This is a rocket docket information case.
It is, Judge.
Okay, this is, was in district court is 26F005. The name, number assigned here is 26CR009. Is proceeding by information. Did you agree to proceed by information? The information charges you with possession of controlled substance, first degree meth. And also possession of drug paraphernalia and possession of marijuana. Do you acknowledge the information counsel received the information?
Yes, sir.
Okay. I waive formal reading and arraignment, and he's going to enter a plea. Is that
That's correct, Judge.
Is this a felony plea?
It's a diversion, Your Honor.
Okay. I've just been informed that you wish to enter a plea today. Is that correct? Or you have to speak up. It's a voice activated microphone. Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Okay. Is your plea freely and voluntarily?
Sir.
You're the same person that we just identified
Yes, sir.
in 26 CR009. Is that correct?
Yes, sir.
Is your judgment impaired in any way
Yes, sir.
today? Have you discussed these charges with your attorney? Are you satisfied with his
Yes, sir.
advice? Have you reviewed the evidence which the Commonwealth has against you? Do you believe you've been fully informed about the
Yes,
case?
sir.
You understand that you do not have to enter guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You got a right not to testify against yourself. No one can make you say. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to call the Commonwealth to plead no reasonable doubt that you're guilty of charge against you understood. By entering a plea today, you go back to those rights.
Yes, sir.
Now, we consider the Commonwealth's recommendation by applying range of sense provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. And I'm going to ask you a couple of qualifying questions. Have you previously been diverted in the last 5 years? You have any felonies in the past 10 years? Are you currently on probation?
First start today.
Do what?
First start today. Starting on this case today.
You understand that if you fully complete the diversion program, the charges will be dismissed and you can have your record expunged. But if you don't successfully complete the program, you brought back in front of me, I revoke you as a convicted felon. That could be used against you. You understand that?
Yes, sir.
Mr. Hunley, what's the Commonwealth's record?
Upon plea of guilty to possession of a controlled substance first degree, namely methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 3 years. The diversion is to be supervised. The defendant shall be assessed and follow any recommendations of the social service clinician, and the defendant shall receive credit for time served, shall, as a part of the supervision, obtain gainful employment or do a minimum of 30 hours community service per week until work is obtained. And agrees that any evidence obtained in this case be destroyed in a manner consistent with the laws of the Commonwealth.
Is that your understanding of Commonwealth's offer?
Sir.
Are you pleading guilty because you did commit the acts charged in the indictment? Are you pleading guilty because you did commit the acts charged in the
Yes, sir.
information?
Yes, sir.
Are you doing so of your own free will?
Yes, sir.
Knowing your constitutional rights explained to you, is it still your desire to give up those rights, enter plea you guilty and allow the court to reach your punishments?
Sir.
Is that your signature on the motion and all?
Yes, sir.
I'll accept the agreement. What's the court cost?
$250.
You get some time to pay that?
How much?
215. I'll let you pay it $30 a month. The first payment due 30 days today. So make sure you do it, okay?
Thank you.
I'll accept the pretrial diversion. That was his signature on there, do you identify?
Yeah, I think the paperwork is actually in the.
I don't have it.
Wow.
So let me verify that signature. Okay, I'll accept it, sign the order. There wasn't any time to serve it.
What is that?
You need to meet with the probation parole officer right there. Jerry Compton. Commonwealth versus Jerry Compton. 26 CR 006 Jerry Compton.
Yes, sir.
Good morning. You were born in 1973.
Yes.
Last four digits, social security number 4287. This is Mr. Cross's case. I think he's in court in Metcalfe County and see who's going to be a little late.
That's correct.
Okay, so we'll pass over your case and call you back. Okay. Cromwell versus Mary Crawford. Mary Crawford. Okay. Okay, well, let's pass over Mary Crawford and go to David Freeman. Cromwell versus David Freeman. Are you David Freeman? Good morning. You were born in 1980.
Yes, sir.
The last four digits, social security number 3407. You're in 26 CR 0015. You have an attorney,
Had one in the lower.
public defender's office.
Yes, sir.
This gentleman is represented by the public defender's office in district court. I will continue the appointment.
Jerry Compton.
The grand jury of Cumberland County has returned an indictment charging you with possession of a handgun by a convicted felon of sexual abuse first degree, 3 counts. Indecent exposure, first degree, 3 counts. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, preserving all pretrial motions?
Yes, Your Honor.
Sign a reciprocal discovery order that will require the Commonwealth to provide you with information. Defense. When is your negotiation day?
April 13th, 9 o'clock.
You should be here April 13th at 9 o'clock and April 23rd. Both of those are conditions of your bond. The 13th, the negotiation, and 23rd is the next time we do. So you need to make arrangements to see your attorney.
Yeah, just hang tight, don't leave.
Beth Garman. Good morning.
Morning, sir.
Commonwealth versus Beth Garman. 25 CR 0064. You are Beth Garman, born in 1973. Last four digits, social security number 3470. You're here for sentencing. Have you looked at the pre-sentence investigation?
We have, Your Honor.
Is it substantially correct?
It is, sir.
Is there any reason they should not be sentenced today?
No, Your Honor.
Or pleaded guilty to operating a motor vehicle under the influence? The defendant should receive a sentence of 5 years, serve 120 days without probate for 5 years. Is that the only charge here?
Yes.
Now, this morning I received a call from the jailer who was going to try to be here tonight. He has concerns about whether they will accept her at the Adair County Jail because of her medical condition, because they don't have a nurse there on duty all the time, especially on the weekends. Now, I don't usually delay sentencing, but that raised Thomas J. Brown. I don't think he's ever called me in all the years he's been on a situation like this, about that. What do you have to say about that, Mr. Poindexter?
Your Honor, there's actually a case on point
I'm not talking about the case, I'm talking about the facts.
Oh, yes, sir. So it's the court's discretion whether or not she serves that time on home incarceration. There is a case on point called Rice versus Commonwealth that was a DUI fourth that the Kentucky Supreme Court says that the court can let them serve the remainder of their time on home incarceration. She's got 54 days credit, so she would have 66 days left. And so that's what we're asking the court to do.
Well, I don't have any doctor statements or anything. You know, I've seen her in a bad situation when she comes here. And her grandmother actually came to my house to attempt to speak to me about that. His mother, her mother came to my house. I said, grandma. And I told her I couldn't talk to her about it. Didn't talk to her about it. I'm disclosing that. What's your position on this, Mr. Stock?
Well, it puts me in a difficult position because I think of one of the cases, and I'm not saying Mrs. Garvin does this without any proof. I don't know what her condition is and whether she can serve in jail. I remember Mr. Cross had a client in Clinton County, he always told his oxygen tank with him. But then when the sheriff came to his door, one time they had him on video, he was jumping, he could almost do jumping jacks. And I'm not saying Miss Garvin's like that, but I think we need some medical proof is my
What I'm
point.
gonna do is go ahead and sentence her today. And I'm gonna they'll examine her for intake at the Adair County Jail. And she probably won't get out of the Adair County Jail with a Class D felon. For the time people think she probably serve out that situation.
And Your Honor, just for the record, we have submitted documents from her doctor with her diagnosis and her prognosis prior to her plea, so they're in the court file.
Okay, I'll take a look at those.
Okay.
Have you seen those?
You may have furnished them to me, I've not. looked
We
at
have.
it. Yeah.
Okay, well, I will see what they say at the intake up there too. See, and I would think that the medical records should be sent with her. When she goes, who's transporter? Is Tom Shea coming back to transporter or?
His assistance is here back.
Okay, we'll give those medical records to them. Okay, what's court cost?
$690.
$695, and you can start paying that at $30 a month. 30 days after your release. We'll take a look and see what they say. That should happen in time for us to make some decision on it today. If they take her on up there and they look at her at the jail, if they refuse to take her, then we'll have to deal with that then, okay?
Yes, sir. That was previously submitted before the plea. Just let the court know. The
You're talking about the medical record?
Yes, sir.
Yeah, well, see, I have a lot of cases. I didn't remember that they were submitted before the.
I understand, Your Honor.
Accept your word for that. We'll pull those and make sure they make a copy of those and make sure they go up with her to make sure they look at the medical
It's a
situation.
letter from Supervisor.
Is that just a letter from the,
There's also some Jane Crawford hospital records, but I can go over there and talk to the clerk.
I don't want you talking to the clerk.
Well, I just want to show her, make sure.
Talk to this clerk over here, okay?
Okay.
Send the file over this way. Okay, well, thank you very much, and we'll keep our eye on it, and Mr. Poindexter, you just make sure you're available this morning. Sometimes if they call back, we'll take her.
Yes, Your Honor.
Commonwealth versus Bobby Garment. Commonwealth versus Bobby Garman, 25 CR 0066. Are you Bobby Garman?
Yes, sir.
Were you born in 2001?
Yes, sir.
Last four digits, social security number 1566.
Sir.
This is a motion to release bond. What is this?
Yes, Your Honor. We had a bond assignment on his case. I did not represent him here in Cumberland County. I represented him in Metcalfe County based on this bond assignment being payment. And so we're asking that that bond assignment be released because it was not his money that was posted. It was his mother, Beth Garment's money that was posted.
I'm a little lost.
Well, so I was
You
told,
represented Metcalfe County. He had a cash bond up here.
yes, sir.
And they made a bond assignment to you.
Yes, sir.
That is the case in Metcalfe County finished, or?
Yes,
This
sir.
case here finished?
Both of them are.
How do you feel about it? It's not your money and she just left, right?
$8 for $4. I know we got restitution.
I think you have $60 on what costs us okay.
What about restitution?
He's gonna make us another thing.
How much is the restitution?
Well, it was about 20-some thousand here, and I had that guy, Grayson. Him hold it. It would, you know, it'd be a long time before that's what comes into some money.
What's your position on it?
I don't have any objection to the releasing because right now, Mr. Warren is doing well, and I hope he continues to do well. He'll either pay it or he'll go to prison. I hope he pays. And he's in specialty court, and I think he's doing well in that. It's not like they can tax this money anyway, it's his money.
I don't know whether all the time I've been practicing law, I've ever seen a bond assignment on a case that would involve the case that was in front of us, that you go get a bond assignment on somebody else's case. I don't know about that. Not running the bank, you know, let me take it under, I'll take it under consideration, get it straight in my mind.
Okay.
Yeah, and it would have been nice if we brought it up while she was out here to see what her position on it. It's her money, right?
Yes, sir.
I tell you what I'm gonna do. Why do we still have the bond?
Because they said it couldn't be released because of restitution.
Yeah, that is a problem. It's not his money. It wasn't released because the restitution had been paid, but we're gonna release it now.
Yeah, there's two problems. There's one, I don't see any benefit of holding the money if it's hurt because the victims can't attach to the money. You know, they can't sue you and get a judgment attached to money if it's hurt money. And if you do, I guess it's a problem, keep holding the money if it's hurt. So it's an odd situation.
I'm gonna release the money to her. And you can do with her what you need to do that way. I'm not going, I'll release it, have the check made to her.
She signed the $7,500 bonus.
You want,
She signed the bonus on it for $7,500, so she wanted extra.
I'm not gonna accept a bond assignment on a different case. Yeah, I appreciate it, but I will make the check to her and you and her can work your deal.
Okay.
Okay. Thank you very much. Jason Graham.